legal decisions that affect your life today. This is cases that shaped America.
A man carrying fireworks jumps onto a moving train. The package slips. An explosion shakes the platform. A heavy metal scale crashes onto a woman standing far away. And, decades later, courts across America still argue about who should be responsible. This is the story of Palsgraf v. Long Island Railroad Co., and one of the most important legal questions in American history. The date was August 24th, 1924. The place, a Long Island Railroad station in New York. Passengers were boarding. Train conductors were helping people move quickly before departure. One passenger began running toward a moving train. He was carrying a small package wrapped in newspaper. Railroad employees saw him struggling to board. One employee pulled from inside. Another pushed from behind. The passenger made it onto the train. But, in that split second, the package fell. No one knew what was inside. It hit the ground and exploded. Inside the package were fireworks. The blast rattled the station. Shockwaves spread down the platform. And, far away from the explosion, a large coin-operated scale toppled over. It struck a woman named Helen Palsgraf. She had not helped the passenger. She had not touched the package. She was simply standing on the platform. And suddenly, she was injured. It seemed like a freak accident. But what happened next changed negligence law forever. Because Helen Palsgraf sued the railroad, and she argued the railroad caused her injuries. But the railroad asked one powerful question. How could they be responsible for harm they never saw coming? And soon, one of America's most famous judges would answer that question, with a ruling still debated a century later. Moved through New York courts. And the legal issue became much bigger than one train platform, because this wasn't only about fireworks or a falling scale. It became about a foundational question. When does negligence legally begin? Helen Palsgraf argued the railroad employees acted carelessly. They helped push and pull a passenger onto a moving train. That caused the package to fall. The fireworks exploded. The explosion caused the scale to topple. And the railroad should be liable. Simple enough, but the railroad disagreed. Their argument was powerful. The employees had no idea the package contained fireworks. The package looked harmless. Nothing about it suggested danger, and Helen Palsgraf was standing far away. The railroad argued, even if employees acted carelessly, they could not reasonably foresee this chain reaction. And that word, foreseeability, became everything. The lower court sided with Palsgraf. But the railroad appealed. Then the case reached New York's highest court. And that's when Judge Benjamin Cardozo stepped in. Cardozo was already known as one of the sharpest legal minds in America, and his opinion would define negligence for generations. But another judge sitting beside him saw the case completely differently, and their disagreement still shapes lawsuits today. Court was split. Same facts, same accident. Two judges. Two completely different visions of responsibility. Judge Benjamin Cardozo wrote the majority opinion. His view became famous. Cardozo said negligence depends on duty, and duty depends on foreseeability. In simple terms, a defendant owes a duty only to people who are foreseeably at risk. The railroad employees may have risked harm to the passenger, maybe nearby people. But Helen Palsgraf? Standing farther away? In Cardozo's view, she was outside the zone of foreseeable danger, meaning no legal duty, no negligence, no liability. But Judge William Andrews strongly disagreed. He argued, once negligent conduct starts a harmful chain reaction, the defendant may be responsible for all direct consequences, even if the exact injury wasn't predictable. This was a huge difference. Cardozo asked, was this person foreseeably at risk? Andrews asked, did negligence directly cause the injury? That debate still divides courts and lawyers, even today. And the reason this matters today goes far beyond trains and fireworks. It affects millions of people right now. 100 years later, Palsgraf still shapes American law because the same question keeps coming back. Who should be legally responsible when one action causes unexpected harm? Modern courts still rely on Palsgraf when deciding product liability, mass injury lawsuits, corporate negligence, chain reaction accidents, construction injuries, transportation cases, and environmental harm. Whenever one act creates unexpected consequences, lawyers still ask, was the harm foreseeable? Or did the defendant create a chain reaction they should answer for? That's why every law student still studies Palsgraf, and why Cardozo's opinion became legendary. Because the case wasn't only about one accident, it asked a question every legal system must answer. How far should responsibility extend? Should people answer only for risks they can reasonably predict? Or for every direct consequence their actions trigger? That tension never disappeared, and likely never will. Because one moment on a train platform, a push, a falling package, an explosion, became one of the most influential negligence cases in American history, and a legal debate still shaping America today. Subscribe for the next case that shaped America.